Hello and welcome. This media recording accompanies the course Political Science 4501 and 5501, International Law, taught by Dr. Greg Dixon of the University of West Georgia's Department of Political Science and Planning. This media recording and all course materials are copyright 2014 by Gregory C. Dixon, and all rights are reserved. Students, staff, and faculty of the University of West Georgia have permission to copy, transfer, or otherwise use these recordings for nonprofit educational purposes. Welcome back. This is part 2 of International Law in IR, Historical and Contextual Background of Contemporary International Law. We're going to do a quick survey of law, particularly sort of internationally developed laws, in the Western tradition and in history. One of the other things we're going to look at here is the presence of colonialism and some of the historical legacies that have gone into international law. And we're going to talk about some key terms and some key concepts having to do with how international law is practiced and how we think about international law, how we think about law, period, to some extent, but also particularly how some of these distinctions apply in the international context. One of the things that will help for an understanding of international law is we're going to look at the development of law in the world. This is one of those things that I do in my lectures where I give you a really brief snapshot of something that is actually super complicated. And in giving you that snapshot, I'm basically introducing you to the fact that there's a bunch of information out there. So this is by no means meant to be something that really covers all of this, but it's designed to give you a real quick, straightforward discussion. Some of this information is in the textbook. Some of this information is stuff that you'll have to look up and read about. If this class is going to cover everything that we need to cover, unfortunately, we do not have time to go into absolutely every element in detail. So if you're interested in sort of the history and development of international law, let me know and I can push you into the direction of some additional sources. But generally speaking, this is designed to give everyone in the course a basic framework. We're going to have to take a brief trip through history. Veterans of my classes know that I love the brief trip through history to refresh everyone's memories. To start off with, this is actually a helpful question. What is law? We think about what we know as law all the time. We think about, I know what law is, but what really is law? And in the context of this class, and I think it's very useful to have a set definition that we can operate from, law is the recognized legitimate standard of behavior that binds a community together. Law is the recognized legitimate standard of behavior that binds a community together. Law is universal. It applies to everyone. The famous quote from Thomas Jefferson is that we are a nation of laws and not of men. Law must apply to everyone equally, whether they are powerful, whether they hold political power or they don't, whether they are rich or poor. The rule of law, when we talk about it, is based on this universality, in part. There are other elements as well. But if law does not apply to everyone equally, then you do not have the rule of law. You may as well not have law at all, because if it doesn't apply to everyone equally, then you don't have a universal foundation. Law is coercive. Violators will be punished. This sounds kind of mean. It kind of sounds bad when you say it that way. Law is coercive. But in fact, we want law to be coercive. There will always be people who do not comply with the legitimate standard of behavior in a community. There are people who will murder other people. There will be people who steal from other people. There will be people who engage in all kinds of other behaviors that are dangerous to the community. And coercion is oftentimes the only really universally recognized way of dealing with them. If you have a serial killer asking them to please stop murdering people just isn't going to work. You ultimately are going to have to coerce them to stop. People who have shown high recidivism, they've been through the judicial process, but they keep offending, they keep violating the norms of society, ultimately coercion is how we deal with them. In the United States, we have a prison industrial complex. We coerce a lot of people for a lot of things into incarceration, and there's a huge argument over the degree to which we should be using this kind of coercion. But we do not disagree with the fundamental principle that criminals should be punished. So you might argue that the fact that the majority of people in prison in the United States are there for nonviolent drug-related offenses, you might argue that that's wrong. You might argue that the school-to-prison pipeline, which sends minority men to prison at greater rates than it does to college, is wrong. But even the most ardent advocates for changing those two structures do not disagree that society has to coerce certain people into compliance with the law or remove them from society. One of the funny things is that while law is coercive, it is also permissive. Individuals can establish their own relationships within the framework of the law. The law in the United States allows the ownership of private property. It allows you to go out and establish your own businesses within certain frameworks, and you can establish your own relationships within that legal structure. If I want to start a business, I start Dixon Analytics to go out and provide services, consulting services for data analysis, I can do that. I can sign contracts with other businesses. I can go out and seek business so long as I get a business license and establish all the various legal frameworks that go along with owning a business. So law is permissive. We can establish individual relationships within that framework. So law here is basically a system in which a community can agree on certain standards of behavior that will apply to everyone. The community agrees to accept coercion as a way of making people who don't want to go along, and it is permissive because within the framework of those rules, members of the community are free to do what they want as individuals. Why do we invent this? One of the great sort of jokes and all about the United States is, what do you call 500,000 lawyers all dumped in the bottom of the sea to drown? And the answer is a good start, because we have so many lawyers and everybody gets mad and all things like that. Now, this is a political science class. There's probably a lot of people going to law school who don't like that joke. But we oftentimes in the United States treat lawyers as sort of a bad thing, and we talk about, lawyers, blah, ambulance chasers, blah. And it's one of those things where the law, while on one hand we look at it as a nice professional career path, on the other hand we grouse about it all the time. So lawyers are kind of a weird thing. We go back and forth about whether we like them or not. But lawyers, whether you like them or not, and whether you think that a joke about them at the bottom of the sea is funny or not, lawyers are there because society has to have rules. We have to have people trained in those rules and in the processes that exist for enforcing those rules. All societies everywhere have rules. Small societies don't need a bunch of rules written down. If you've got a community of 100 people, you know everybody in that community. You know everyone. You know all their quirks, all their foibles, because there's only 100 of you. Think about a hunter-gatherer society, and everyone in the community knows everyone. Everyone in the community cooperates to promote survival. So everyone knows everybody. You don't need to have hundreds of thousands of pages of laws, because you don't need to. You don't need 1,000 pages of law for every person in the community. Because ultimately, a social structure, a society based on the principle of generalized reciprocity, where everyone gives today on the assumption that when they're in need, someone will give to them later, all of that is completely workable. If you have a serial killer in a community of 100 people, then it isn't the same challenge as a serial killer in a society of hundreds of millions. If you're the serial killer type and you're in a very small community, you generally have a hunting accident relatively early on because society won't tolerate you. And in a small society with informal rules, this is what happens. One of the famous cases of this is there were a group of anthropologists who went out in Papua New Guinea in the 1960s to study a local community that had almost no contact with the outside world. And one of the things that happened was one of the anthropologists slept with a middle teenage girl who was unmarried in the community, and the locals took it to be against the girl's will. And so one day, all of the anthropologists woke up and they were one short. The individual who had undertaken this inappropriate sexual activity had simply vanished. And the local community kind of said, oh, yeah, we don't know. He got up in the middle of the night and we never saw him again. Well, it was obvious what had happened. The family members of the girl killed him and dumped his body in the forest. Small societies don't need a big set of formal rules because they have ways of dealing with these things informally. There's no trial. There's no nothing. This is a couple hundred people. They know what happened. They know who the perpetrator was, so they simply deal with it. Now, we today may find that horrifying. we may not like the whole idea of, wow, if you screw up, someone can just kill you, and everyone's like, yeah, he had it coming, and that's it. We like our due process. But part of that is that we live in large societies. We have to have formal rules. If I, as somebody who grew up in Southern California, who spent his graduate school years in Arizona, come to Georgia, and I violate some social rule, I would prefer not to be killed for it. And because I'm a stranger in a community where no one knows me, in a system with no rules, I might come in, sit down in a bar, and have somebody say the sort of typical greeting that Southerners do, where someone who doesn't necessarily know you comes in and says hi. And the sort of weird thing in the South where people say, oh, be safe. In Southern California, be safe means that there's someone out to get me and I should be looking over my shoulder. And it's sort of seen in some contexts as actually a threat. That could easily be a misunderstanding. If there's no formal rule and you have to sort of solve everything yourself, it can be more challenging when you don't know anyone. And in a large-scale society, you're just not going to be able to know everyone. Carrollton, Georgia is a tiny town. Everybody knows everybody. Everybody knows everybody's business. It is a tiny town that's very, very interested in gossip. I've just been absolutely amazed at the number of times where something as weird as sitting at the grocery store talking to somebody in casual terms as we're waiting in line for a checkout turns out that they have heard of me somehow. Their friend's cousin was at a Rotary talk that I gave, or their friend's daughter was in my class. Like weird little things all the time. Or I'll run into people and they will know what my house looks like because they've driven by when I was out in the yard working. So it's a small town and it has all these weird things. But even with only 25,000 people, you can't possibly know everybody. We're only biologically wired to know about somewhere between 500 and 1,000, depending on whose work you want to believe on the matter. So in a large society, we got to have formal rules, and we have to have impartial enforcement. Because if you don't know everybody, you're going to constantly run into strangers. You cannot trust that strangers will behave the way members of your inner community will, because there's no generalized reciprocity. You may never meet them again. So you have no reason to assume that they will follow the rules. Plus, we are really good as human beings at divvying people up and stereotyping them. And so we see, even in modern America, where we like to think we're past these, we have incidents where people are literally killed over what are basically misunderstandings in terms of community. Someone's playing loud music. I associate that loud music in my mind with a certain type of culture, whether it's death metal culture or rap culture or whatever subculture. I have a certain image in my head. If it's me and I'm a college professor and I'm like, I don't care what people do or what music they listen to, and sometimes it's, I don't really know anything about this music, but the beat's kind of cool. Hey, I don't mind that it's loud. I have a very tolerant worldview because of my socialization. Other people don't. And recently there was actually an incident in which a teenager from the Atlanta area was killed in a situation in which a guy was hearing loud music and saw a bunch of people who were African American in a car, and his mindset was African American males are dangerous. They're playing loud music, another level of danger because they're violating social norms and violating the audio space of everyone around them. And so when one of them started to get out of the car, the guy freaked out and thought he was in danger and shot the poor kid, killed him. And the problem here is that's what happens when you don't have rules. And in our society, that person was prosecuted and convicted. So large societies need rules like this because you have to have some third-party enforcer. You can't have, when strangers interact, force ruling. You can't pull your gun because you think the people next to you are dangerous because of some stereotype. Because if you do that, society can't function. If everybody pulled a gun and opened fire every time they felt uncomfortable, there wouldn't be very much of civilization left. It would be a Hobbesian nightmare, a war of all against all. So we have formal rules with enforcement to save us from that. It's this kind of thing that makes the world a lot easier. Law makes our lives so much simpler. We all know the rules. Now, just because we all know the rules and 99.99999% of us comply with them doesn't mean the rules won't be broken. It doesn't mean that people won't behave inappropriately. It doesn't mean that you won't have somebody occasionally who pulls his gun out and opens fire on people. What it does mean is that those people suffer the consequences as defined by society. And you know what those rules are. We know that there are these big spectacular cases because we have television and the internet today. So these extremely rare cases, we all find out about them. But we all know that the rules are violated. Now, we may disagree on what the appropriate punishments are. This particular case where the individual was prosecuted and convicted in Florida for shooting this Atlanta area teenager, there were big disagreements about what the appropriate punishment was. There were a lot of people really mad that he didn't get a first-degree murder conviction. But in our laws, first-degree murder generally requires premeditation. And this was a guy who freaked out. It wasn't premeditated in the legal sense. So people don't necessarily end up happy in the situation. But at the same time, you do have circumstances in which we know the rules. The biggest thing is when you move out of the criminal world into the economic world, laws let you make long-term decisions. I know that if I sign a contract with you that has a 20-year horizon to it, we're going to work together for 20 years, I can go to a third party to enforce it. I can make deals with people far away that I've never met. I can go online and I can sign an agreement with somebody. I can pay Amazon.com to send me Shaw's International Law Book. Because I know that they're going to do it. Why? We have a contract. We have an agreement. They agree to do it. And if they don't, they fail to perform, I can take them to court. Now, whether I'm going to do that over a $50 international law book, well, that may not matter. But if I'm going to build a factory, I need to pick where, just recently, Toyota moved its national headquarters from Torrance, California to a suburb of Dallas. Well, I'm going to move my national headquarters. I need to know that for at least the next 20 years and probably longer, I'm going to be able to trust the assurances that I'm given from the contractors, from the people building it, from the cities, everything else. So long-term decisions with people far away are important. And ultimately, when you disagree, because people often do, there's some enforcer that's out there. So I started this whole section off with this sort of joke about lawyers, but in reality, we need lawyers. We have to have lawyers because they're the experts in the law, which society has to have anytime you get more than a few thousand people. There has to be someone who's an expert in law. There have to be people who are professionals at enforcing the rules and adjudicating disputes. So we have to have people who know the law and who can represent us in these cases, because we don't have time to become experts. Even if we had a libertarian paradise in the United States, the government would still have to enforce contracts. So even if there was the libertarian universe where the government did the absolute bare minimum, very, very different from what we have today, you'd still have a government judiciary to enforce contract law, because you have to have that. Could you privatize it? Well, I can conceive of different ways you can do it, but nobody's done it successfully yet. The problem with the privatization of contract enforcement is it's not universal. You have to have universality to be law by our definition. So we have to have those people. So I joked about lawyers in the beginning, started it off with that, partly because I know a bunch of the people listening are lawyers, and so I'll take my little sort of moments to make fun of them a little bit. But at the same time, what they do is absolutely essential. So if you're thinking of going to law school, you are in fact picking a noble profession. Just hopefully you'll go to a grad school, law school that's high enough ranked that your job won't be replaced by machines fairly soon, which is one of the difficulties of modern law school decision making. We basically, when we talk about law, have two types. And one of the things here is I'm including Latin terms for those who are interested, particularly for those who are planning on eventually going to law school. The difficulty is that there are multiple Latin terms that are used sometimes. I'm using the most commonly used ones, but you'll see occasionally for things like positive law, alternate ways of saying it. But we basically have two core types that matter for us. There are some others, but the two that really matter for us are natural law, lex naturalis, and that is a pre-existing system of rules that apply to all people everywhere that derive not from any individual person's decision, but from nature itself. Natural law can be thought of as a divine law in the sense that a divine creator orders the universe, and in that ordering of the universe is this natural law. Natural law, though, is normally thought of as something that derives from specifically the nature of reality itself. So everybody has this legal framework. It's completely universal. It applies to absolutely everyone, everywhere, because it comes from us as human beings. Positive law, lex posita, is law that is created by the polity. It's the law of the political system. It is derived from a legitimate authority. Now, this is really important. Lex posita is derived from a legitimate authority. It comes from the polity. There is another way of thinking about this, which is lex humana, which is law derived from human beings. Lex humana can be any law that comes from a person. Lex posita is law that comes from legitimate authority. And this is a really big distinction. There's a reason that lex humana is not included in the slide that I'm showing here on the video version of this. Lex posita derives from legitimate authority. We only really want law from legitimate authorities. A dictator can say that they're going to rename the calendar, and the new law says that January has to be called Gregory instead of January. I'm dictator, I'm going to make January my month. I'd more likely make June or some summer month my month. But if I was going all dictator, maybe I'd make them every month. All 12 months are Gregory. Who knows? Dictators can be crazy. Well, a dictator's crazy laws are lex humana. They're derived from a human being. But they are not lex posita because they're not legitimate, because they don't apply to everybody. They don't meet our conditions of law. So one of the challenges for us is that there can be overlap. Well, if a dictator rules a country, the polity includes a dictator at its head. So that would be lex posita, right? Well, now you're back in where we were arguing. People argue about this. Where lex posita originally comes from is an argument that positive law derives its legitimacy from the degree to which it complies with God's law. Natural law is the law that derives from God's ordering of the universe. Positive law is law that derives from God's covenant with Christians. And so the early versions of these are different from how we think of them today. But when you're thinking about positive law today, what you want to think about is that the authority from which it is derived is legitimate. And we don't require that that be divine today, although the Islamic Sharia legal system would say that, yes, it has to be ultimately derived from Allah. And there are many conservative Christians in the American equivalent of that sort of way of thinking that argue that all law has to come from God. But in the normal legal discourse and in the legal decision-making in Western countries today, we separate sacred and secular, and so positive law can be thought of as deriving from legitimate authority. This conversation, though, about these two areas is going to be something that is indicative of a lot of what we're talking about, multiple ways of understanding the same thing and definitions that have changed over time. What I would tell most of you, anyone who's not going to be a lawyer for sure, but most of you, don't necessarily get bogged down in these distinctions, in all the little details. Just think of this in terms of a natural law that derives from nature and that applies to every human being everywhere universally, and a positive law which we create to legitimately govern the behavior of individuals in our communities. International law, as we currently understand it, is Western law. Now, when I say things like this, there's a whole thing in the modern academy where people get pissed. They get mad at me because they're like, oh, well, you're glorifying Western law. I'm not glorifying Western law. Western law has some cool things about it and some terrible things about it. But the fact is that modern international law is Western. It's not derived from anything else. It's Western law. Whether you like it or not, it's Western law. It's the product of Western civilization, which has really important ramifications for how international law is structured and how it works. International law as it exists today is a weird mix of Roman, Germanic, and other kinds of law. It's because it comes from the complex and slightly goofy history of Western civilization that international law combines all these different elements. The biggest thing that matters for us is that international law, as practiced today in the framework set up in the United Nations system after World War II, embeds a whole series of Western assumptions about what law is and how it works into the structure of the international legal system. So, not saying that Western law is awesome and it's great that it is this way. I'm just saying it is this way. This is one of those things where I get criticized by some colleagues because they often say that, well, when you say things like this, it's glorifying Western civilization. I'm not glorifying it. I'm just telling you that if you want to understand it, this is the way that it goes. One of the challenges in the modern era is we no longer teach classes in Western civilization. So I wouldn't have had to have a slide like this 30 years ago because everyone would simply have understood the origins of the Western intellectual tradition, and it would have been common knowledge that international law derives from that. We no longer teach Western civilization. In fact, we teach almost nothing of the traditions of any civilization. We replaced Western civilization with no civilization in terms of our really deep understanding of things. But the problem with that is that it leaves structures like this much more confusing than they need to be. The Western influence in particular has a couple of really key elements. The biggest thing that we will run into over and over again in this class is sovereignty. Sovereignty is the concept that no outside authority can legitimately coerce a state to do anything it doesn't want to do. So states are all formally equal in international law. The United States is formally equal to the little tiny island nation of Vanuatu in international law because both are sovereign entities. Even though the United States has 300 million people and Vanuatu has 400,000 people, we are equal in the eyes of the international system. The United Nations enshrines this concept into its charter. All international law, as we currently practice it, with the sole exception of the Genocide Convention, focuses on sovereignty as a key element. The Genocide Convention is the only piece of international law that explicitly discards sovereignty and creates an obligation to intervene to stop genocide regardless of sovereignty. The other really big thing that gets embedded into international law that is entirely the product of the West is a separation of natural and positive law. This derives from the separation of sacred and secular. Remember, originally what they were doing with these is they were taking the law that existed in nature because of God's design of the universe and pulling that out of the law that derived from God's commandments. And so essentially there is this naturally derived order, and then there's this order that is legitimized by having God's stamp on it. But the king makes the laws, and as long as they're in compliance with God's covenant, it's okay. But it's separate from the universal rules that we all have to follow, which also derive from God. In the Protestant Reformation and in the wars over religion that take place, ultimately ending with the Treaty of Westphalia, there is a separation of law from the sacred world. And in making that separation, what we see is the origins of what will come in the United States to be seen as the separation of church and state. In reality, all Western law assumes a separation of sacred and secular. And importantly then, there is a separation of sacred and secular authority in international law. This is not a trivial thing. This is absolutely key. It is only in the Western tradition that you have this stark separation of church and state, of sacred and secular, of divine and temporal. We are the only society that created this stark difference. And we didn't create it because it's something inherent in Western civilization. For the vast majority of the history of Christian civilization, sacred and secular were unified. It's only within the last 400 years or so that stark separations have really become the norm. And they became the norm not because somebody said, hey, this is a good idea. They became the norm because they were fighting religious wars that were so terrible that they opened up Western civilization to potential attacks from the outside by Islamic civilization, and that worried everybody to the point where they changed what they were doing. So this is huge, because what's going to happen is when we build the current system of international law based on the UN Charter, following the Second World War, we will enshrine this concept, separation of natural and positive law. The UN doesn't say, God says that these are the rules you should follow. Because a bunch of people in the world, not Christian, not Islamic, not Jewish. So even if you want to take the Abrahamic faiths and assume the one Abrahamic God that would dominate those three faiths and enshrine that into the United Nations, there's a whole bunch of people in the world, a majority of the world's population, who would disagree with you because they don't share your religion. And this is one of the challenges that gets faced. Because there can be no religious foundation of international law retains this sacred and secular and focuses on the secular. So the Western influence is key. The problem is Western influence is really embedded in legal structures, but how did it get that way? Well, Western legal modality is not spread because everyone said, hey, that's an awesome idea, let's totally borrow that. It was spread because the West basically conquered and exploited and subjugated everybody. You get the spread of Western law at the end of a sword or the barrel of a musket, or later on the barrel of a rifle. And this is a problem because it ultimately means that for the majority of the world's population, international law in this Western model has a problematic legacy. It is not universally seen as good, even though people practice it. And this is a challenge. The sort of visceral acceptance of this kind of law that we have in the West is not universal. The whole world will come to adopt these models, and we can see this in a million different ways. Former colonial states defend their national sovereignty, even though their borders might be ridiculous. Their borders are just crazy. Their colonial borders. In parts of Africa, the Europeans drew these borders and they didn't even know what was there on the ground. There's a running joke that at the Conference of Berlin, the people got bored, so they went to a pub across the street from the place where they were meeting. And if you look in Africa, you'll occasionally see borders where there's a straight line and there's kind of a little bump. And the joke is those little bumps were from people accidentally kicking the table while they were trying to draw a straight line. They had no idea what the conditions were on the ground when they were dividing up these territories. And Africa is the worst for this because it's the place the Europeans knew the least about and had the least control over. And the result is a set of borders that are oftentimes ridiculous. And yet, modern countries who fought wars to throw off the yoke of colonialism defend their sovereignty and their colonial borders. One of the most interesting elements of this is that indigenous persons groups who have practices that really don't match much that you'll see in most of international law will actually go and argue for indigenous persons' rights in terms of natural rights, using the concept of universal natural human rights.